When filing a suit in court, even prosecutor's office always look into the complainant. It is legal standing to check if you suffered or will suffer damage or injury. If not, it will be dismissed except into certain cases provided by law, of which is the landmark case of minor Oposa versus Factoran, where minors and even unborn or future generations were given legal standing by the court. First disclaimer, our videos on laws are based on actual cases. The facts stated have been made public via publications on the internet. Before, should any data, especially of the petitioner and or the defendant, is offensive in any way whatsoever, kindly leave a comment or message us in our Facebook and we'll be more than happy to oblige. In the case of minor Oposa versus Factoran, GR number 101083, July 13, 1993, the court allowed minors and even unborn to be complainants to a citizen suit for environmental loss. Supreme Court stated, this petition bears upon the right of Filipinos to a balanced and healthful ecology, which the petitioners dramatically associated with the twin concepts of intergenerational responsibility and intergenerational justice. Specifically, it touches on the issue whether the said petitioners have a cause of action to prevent the misappropriation or impairment of Philippine rainforest and arrest the unabated hemorrhage of the country's vital life support system and continued rape of Mother Earth. The controversy started in civil case filed before Makati RTC. The principal plaintiffs are all minors duly represented and joined by their respective parents, and pleaded as an additional plaintiff in the Philippine Ecological Network Incorporation, PENI, a domestic, non-stock, and non-profit corporation organized concerted action geared toward the protection of our environment and natural resources. Original defendant was Fulgencio S. Factoran Jr., DENR Secretary, substituted by the new Secretary, the Honorable Angel C. Alcantara. The complaint was instituted, class suit, and alleges all citizens of the Philippines and entitled to full benefit, use, and enjoyment of the natural resource treasure that is country's virgin tropical rainforests. The minors asseverate that they'll represent their generation as well as generations yet unborn. Consequently, it is prayed for that judgment be rendered, ordering defendant, his agents, representatives, and other persons acting in his behalf to 1. Cancel all existing timber license agreements in the country. 2. Cease and desist from receiving, accepting, processing, renewing, or approving new timber license agreements, granting the plaintiff such other reliefs just and equitable under the premises. The complaint issue focuses on one specific fundamental legal right, the right to a balanced and healthful ecology, which the first time in our nation's constitutional history is solemnly incorporated in the fundamental law. Section 16, Article 2 of the 1987 Constitution explicitly provides, Section 16, the state shall protect and advance the right of the people to a balanced and healthful ecology in accord with the rhythm and harmony of nature. This right unites with the right to health, which is provided for in the preceding section of the same article. Section 15. The state shall protect and promote the right to health of the people and instill health consciousness among them. Issue whether or not the right to a healthful ecology be granted to minors and future generations. Decision, yes. While the right to a balanced and healthful ecology is to be found under the Declaration, principles, and state policies and not under the Bill of Rights, it does not follow that it is not important than any of the civil and political rights enumerated in the latter. Such a right belongs to a different category of rights altogether, for it concerns nothing less than self-preservation and self-propitiation, aptly and fittingly stressed by the petitioners, the advancement of which may be even said to predate all government and constitutions. As a matter of fact, these basic rights need not to be written in constitution, for they are assumed to exist from the inception of humankind. If they are not explicitly mentioned in the fundamental charter, it is because of the well-founded fear of its framers that unless the right to a balanced and healthful ecology and to a health are mandated as a state policies by the Constitution itself, thereby highlighting their continuing importance and imposing upon the state a solemn obligation to preserve the first and protect and advance the second. They would not be too far when all else would be lost, not only for present generation but also for those coming generations which stand to inherit nothing but parched earth incapable of sustaining life. The right to a balanced and healthful ecology carries with the correlative duty to refrain from impairing the environment, conformably with the enunciated right to a balanced and healthful ecology and the right to health, as well as the other related provisions of the Constitution concerning the conservation, development, and utilization of the country's nature resources. Then President Corazon C. Aquino promulgated on the 10th of June 1987 EO number 192, Section 4, of which expressly mandates states that the Department of Environment and Natural Resources shall be primary government agency responsible for the conservation, management, development, and proper use of the country's environment and nature resources, specifically forest and grazing lands, mineral resources including those reservation and watershed areas, and lands of the public domain, as well as the licensing and regulation of natural resources as may be provided by the law in order to ensure equitable sharing of the benefits derived therefrom, the welfares of the present and future generation of Filipinos. Section 3 thereof makes the following statement of policy. Both EO number 192 and the Administrative Code of 1987 have set the objectives which will serve as the basis for policy formulation and have defined the powers and functions of the DENR. It may, however, be recalled that even before the ratification of the 1987 Constitution, specific statutes already paid special attention to the environmental right of the present and future generations. On the 6th of June 1977, PD number 1151, Philippine Environmental Policy, and PD number 1152, Philippine Environment Code, were issued. The former declared a continuing policy of state A. To create, develop, maintain, and improve conditions under which man and nature can thrive in productive and enjoyable harmony together with each other. B. To fulfill the social, economic, and other requirements of present and future generations of Filipinos. And C. To ensure the attainment of an environment quality that is conducive to a life of dignity and well-being. As its goal, of the responsibilities of each generation as trustee and guardian of the environment for succeeding generations. The latter statute, on the other hand, gave flesh to the said policy. Thus, the right of the petitioners and all those they represent to a balanced and healthful ecology is as clear as the DENR's duty under its mandate and by virtue of its power and functions under EO number 192 and the Administrative Code of 1987 to protect and advance the said right. A denial or violation of that right by the other who has the correlative duty or obligation to respect or protect the same gives rise to a cause of action. Petitioners maintain that the granted of the TLAs, which they claim was done with grave abuse of discretion, violated the right to a balanced and healthful ecology. Hence, the full protection thereof requires that no further TLAs should be renewed or granted. After a careful examination of the petitioner's complaint, we find the statements under the introductory affirmatives allegation as well as the specific averments under the subheading cause of action to be adequate enough to show prima facie the claimed violation of the right of the base thereof. They may thus be granted wholly or partly the reliefs prayed for. The Oposa case is also internationally famous because the court recognized the right of the petitioners who were minors to sue as a class on their own and as representatives of generations yet unborn, based on the concept of intergenerational responsibility. This case, however, has a special and novel element. Petitioner minors assert that they represent the generation as well as generations yet unborn. We find no difficulty in ruling that they can, for themselves, for others of their generation, and for the succeeding generations, file a class suit. The personality to sue in behalf of succeeding generations can only be based on the concept of intergenerational responsibility insofar as the right to a balanced and healthful ecology is concerned. Such as a right, as hereinafter expounded, considers the rhythm and the harmony of nature. Nature means the created world in its entirety. Such rhythm and harmony indispensably endue inter alia, jurisdiction, disposition, utilization, management, renewal, and conservation of the country's forests, mineral, land, waters, fissures, wildfires, offshore areas, and other nature resources to the end at their expiration. Development and utilization be equitably accessible to the present as well as the future generations. Needless to say, every generation has responsibility to the next to preserve the rhythm and harmony for the full enjoyment of a balanced and healthful ecology. Put a little differently, the minors assert of their right to a sound environment constitutes at the same time the performance of their obligation to assure the protects of that right for the generations to come.